Officer Dade, would you open my courtroom, please?
The State of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning.
Make sure you
Good morning, Counsel.
Good morning, Your Honor.
I was telling him to make
Trying to
sure.
get the other person here, I think, is on your side.
Still can't hear you, sir. I know he's talking.
It's Deborah Conyer.
Hold up the universal. Wait a minute. Well, not really. He can call the court. You get it on.
Judge, it's possible that we can do this with him just listening.
Well, how about this? How about if I have him call the court's main line and I'll put him on the speakerphone?
Is this Deborah Conyer?
I'm on the computer.
Okay, if he calls your cell and you put him on your speakerphone, then he can communicate.
All right, Mr. Norman. Apparently, I can't get this person now, so I'll put you back in the waiting room. And we'll see if we can't get her another few minutes.
Yes, Your Honor.
Sorry about that.
No problem.
Mr. Falzone, what brings you here this morning? You're muted, sir.
I apologize, Your Honor.
You've got Dana Wethington versus Westfield Insurance.
Yes, sir.
All right, who is D? I have some person named D here, and they have muted. See if I can get them to unmute. All right, who is D? Is there somebody named D on this web call? This person doesn't seem to be there. I don't know who this is. I'm not sure they are with you because you have counsel on the other side, and I don't see Mr. Januszewski as of yet. So I'll put you back in my waiting room.
Yes, sir. Your Honor.
Yes, sir.
I just want to let you know, I also have another Zoom conference going with Judge Bell in Genesee County. I'm trying not to be rude to either one, obviously, sir.
Do the best you can. We'll work it out one way or the other.
Thank you, sir.
It's a lot better than having to drive back and forth.
That's true.
Okay, I'll get back to you.
Thank you, sir.
D, I'm putting you in the waiting room. I don't know who you are. You have failed to answer. I'm not spending any more time with this. So let's get these two on the road. They should be ready.
Your Honor.
Mr. Anderson, good morning. Okay, I see Ms. Beverly. So I think we have everybody now. Let's call our case. This is file number 20158-046, Open MRI of Livonia versus Esurance Property. This is a motion to enter default judgment on behalf of plaintiff open MRI of Livonia, your respective appearances.
Good morning, Your Honor. Harlan Beverly on behalf of the plaintiff, P44028.
Good morning, Your Honor. Zachary Anderson, P71605 on behalf of Esurance.
Ms. Beverly,
Good morning, Your Honor. I would rely upon my brief as well as my reply to defendant's brief in requesting that a default judgment be entered in this case. Your Honor, I feel, just so that I can make a record, we filed this complaint on July 6th of 2020. The court issued its first scheduling order on October 23rd of 20. Since then, Your Honor, I have sent 3 demands. September 22nd of 20, April 27th of 21, and May 3rd of 21. We have come to this court to get answers to interrogatories, which I still don't have, despite the stipulated order that was entered. I do not have written responses to our interrogatories or production requests. And most recently, on this 4-scan 0-pay case, an offer of 17% is very offensive, Your Honor, in addition to the fact that I have appeared here in court on a few occasions on this matter. So I am not understanding how there is a complete disregard for plaintiff's case, for me as plaintiff's counsel, for this court, for the procedures. I don't understand not appearing on dates that are duly noticed. I don't understand not appearing for motions that you file. Everybody knows that if you file a motion and you don't get a hearing date, you call the judge's chambers, you ask the clerk, hey, has a date been scheduled? I don't have it. Or you check the register of action, or you look at the civil Zoom docket, which 36th District is innovative in having, because other courts don't have a civil Zoom docket that you can check every single day. It seems to me that for many, many months, at least 7, this case has been pending with absolutely no action. And Your Honor, I fully believe that there's not been a sufficient showing in their response to my motion for a default judgment as required by the court rule and the case law. But if this court is inclined to entertain it, I would ask for cost, because the court rule requires that if a default is set aside, then there are costs that should be entered. And I would ask for $500, because this isn't once, this is twice, plus the lack of respect for the discovery process. I would also ask that I be allowed to depose the adjuster in this case, because frankly, Your Honor, this case has been in a default status for at least 6 months, because we've been waiting for things to happen, and this just doesn't make any sense.
Mr. Anderson.
Your Honor, I will start by addressing the discovery issue. Counsel has represented that I have not sent the discovery. Attached to my responsive motion are emails. I sent the entire claims file over on December 4th. On January 14th, I got an email stating that they could not open the link. We responded to them saying that the share file link, which is the program we use to send the claims file materials, that it will expire within 14 days if not open, that it will also expire if you forward it to another person. We then resent the claims file on January 15th. So we have responded to discovery. The allegation that I have not produced anything is simply not true. If they have a problem opening it, I can walk them through tech support issues, but nobody's called me and said the link doesn't work. I've been told it expired, I resent it, and that ends my obligation, short of them saying I can't actually open this link. So default for the discovery sanction would be extremely severe and disproportionate based upon the case law I cited in my brief, because I have provided the discovery responses. In regards to the missing court dates that I missed, I admit I missed those 2 dates. Mail in Farmington Hills has been terrible over the past year. There are times where we get 3 months worth of mail in one day. I did not have notice of the last 2 hearings. When counsel emailed me regarding the original default, I emailed her back and I indicated that I was unaware of the court date. I asked if we could stipulate to set the default aside because I was unaware of the court date. She did not say yes or no to my request, which led me to filing a motion to set aside the default.
And then not appear for your own motion.
That is true. My secretary called 3 times. She does not recall the date she called. She did not get through to anybody. Then eventually I became aware of the fact that I missed my own motion. I admit that I did that. I wish I hadn't missed the motion. I was unaware of the motion hearing date. Counsel brings up the register of actions, checking the website, and all of those are, I don't dispute that those things exist. However,
Then why weren't they checked?
I didn't know prior that about the electronic register of actions. I was used to the computers being in the building and checking that way. I did not think to check the court's website. We had just been making phone calls. And unfortunately, we never got through to anybody when we would call.
Is there anything else you want to say?
Your Honor, default would be a harsh judgment in this scenario.
Default's already been entered. The question is whether or not I'm going to enter a default judgment. And the fact of the matter is, counsel, according to what you just told me, there are 2 court dates that you missed, including the hearing on your motion to set aside the default, which had been necessitated by what? Oh, your failure to appear for pretrial.
That is correct, Your Honor. I did not receive either of those dates in the mail for whatever reason. I can say this and I'll say it again. Mail has been terrible in our office. I did not receive either one of those dates.
When did you first realize?
Counsel emailed it.
When did you first realize you were having trouble with your mail?
We have been having problems with the mail for the past year.
Okay, so sometime in May of 2020, long before the court sent out either the notices that issue, you knew you had a problem with your mail.
Yes.
Is that fair to say?
Yes, it is.
Then what was done, sir, recognizing that you had this change in the reliability of your mail to keep you current with court dates? Don't you have a diary system in your office where files come up for review on a periodic basis?
We do review the files.
Indeed. And so you filed a motion to set aside a default judgment that was entered because of your failure to appear for a pretrial. How did you miss that when it came up on your diary date?
Well, I was calling, well, not me specifically, but my secretary was calling. We just never got through to anybody. So we did make attempts to determine what date we should appear.
Let me make sure I understand what you're telling me in response to your claim about not being defaulted for failing to comply with the agreed upon orders for discovery. It is your position that you emailed the matters at issue. And then having learned that there's a problem, you emailed them again. Is that your position?
Yes.
So apparently you have some familiarity with the internet.
Yes, I do.
Can you explain to me then why, since you have familiarity with the internet, the court, 36th District Court has had a website for longer, much longer than a year, you didn't use the website? Since you are familiar with the internet, you're a technological dinosaur like me, that might be one thing. But it seems to me what's happening here, Mr. Anderson, is that when you choose to be tech savvy, you are, then you decide, oh, I didn't know what to do with tech. Seems to be sort of inconsistent, sir.
Well, Your Honor, I admit I can see the inconsistency, and I'm just going to be honest and fall on the sword and say I did not think to check the website.
What prejudice would inure to your client if I do not set aside the default judgment based upon your failing to appear at the pretrial and your failing to appear at your own motion to set aside the default judgment that resulted from that?
My client would be prejudiced because the case would not be decided on the merits, as I cited case law in my brief that the Supreme Court and the Court of Appeals does favor decisions to be made on the merits of the case.
They certainly do.
It's a website.
they do not favor the ignoring of 2 court orders.
That is
You
true.
ignored the court order for the pretrial date. You ignored the court order calendaring your own motion to set aside the default that resulted from your failure to appear.
So, Your Honor, I did not ignore them. I did not have notice of them. While I understand the website exists, based upon my review of the court rules, and the court rules do not acknowledge the website and publication on the website as notice under the court rules.
Notice under the court rules, sir, is mailing by first-class mail to the address you provided with the court. Now, we sent notice by first-class mail, postage prepaid to your office for both the pretrial that you missed and for the motion to set aside the default judgment that you filed but failed to appear for the hearing. So under the court rules, sir, you had service. Please continue with your argument.
I do not dispute that it was mailed. I'm only saying that I never received the notices, and to this date, I have still not received either notice, and it is through no fault of the court. As we all know, the Postal Service has been having significant problems over the last year.
All right, anything else you want to tell me?
No, Your Honor.
Anything else, Ms. Beverly, you want to say?
I just want to clarify, Your Honor, to make sure that I'm clear here. The stipulated order required them to give us written responses to our answers to interrogatories and our request to produce. What counsel or defense did was just send over a claim file. There's not a single written response to an interrogatory or a request for a production of document.
Let's
Just
stop right there. Did you send the written responses to any interrogatories, sir, as was specified in your stipulated order for discovery? Or did you only send the claim file?
The written responses are indeed late, Your Honor. They were sent yesterday, and they still need to be signed. So I do admit that they are late.
So let me make sure I understand. As we sit here today, you have failed to comply with the stipulated order concerning discovery by not sending in signed copies of the written answers to interrogatories. You failed to appear for pretrial. You failed to appear for the motion to set aside the default necessitated by your failure to appear at pretrial. Is that about where we are?
You are correct, Your Honor.
And is my math wrong? And is that 3 strikes?
That is 3, Your Honor. You are correct.
And the case law that you cited, in how many factual instances did you have a party fail to comply with the court order for the drastic sanction of default judgment was entered?
In the case law I cited, they do not specifically list in the portion that I cited how many strikes.
But you read the case. Tell me how many times you had strikes, if you would, in those cases that you rely on, saying that default judgment is too severe a sanction for failure to comply with the court order. Show me a case where it says 3 failures is too severe a sanction.
I cannot come up with a case like that off of the top of my head.
Anybody else want to tell me anything?
Your Honor, I believe that a default judgment is merited under the particular facts of this case. And again, if the court is not willing to do that, I would ask for severe sanctions because I have not had a case with 3 strikes like this, ever, in 30 years of practice.
This is my 43rd year. I haven't seen this before. Mr. Anderson?
Your Honor, I will simply say that my missing of the 2 dates was not intentional. There was malicious intent. It was simply due to factors outside of my control. Certainly, if I had made no attempts to ascertain the court date, that would be far worse. But my office did at the very least attempt to call to ascertain the date on multiple occasions.
Did I miss the affidavit of your secretary in that regard?
There is no affidavit in there. However, I can represent as an officer of the court that she made attempts to contact the court.
And what about your failure to comply with the terms of the order for discovery to which you stipulated? What's that?
That was an oversight on my part. We sent claims file over. I did not realize that my paralegal did not send over the interrogatory responses with them. I did follow up with her about that and made sure she got them over once I realized she did not send over the written responses.
All right, I'm done. I'm prepared to rule. Mr. Anderson, this is the sloppiest lawyering I have seen in a case that I have handled in more than 40 years. There's simply no excuse for your disregard to this case. You stipulate to the entry of an order for discovery, which you failed to comply with. Having failed to appear for pretrial, let's say that's excusable. You failed to be interested enough in the case to find out the hearing date for the motion on your request to set aside the default that came from your failure to appear. None of the cases that you cite involve a situation where you have 3 violations of a court order by one party, when the Court of Appeals said default judgment was too severe sanction. This is the worst lawyering I've seen. But I do think that it would be inappropriate because there has been an answer filed. You have made some efforts, although incomplete, to comply with the order for discovery, to enter the severe sanction of default judgment. What I'm going to do, the court is going to deny the motion to enter default judgment and set aside the default, contingent upon payment of attorney fees of $750 by the defendant to the plaintiff within 10 days of today. And let me make this perfectly clear, Mr. Anderson, going forward. Any failure to comply with any order of the court going forward here will result in a default judgment, and I will not hear any more excuses here. You are responsible for the responses filed under the discovery rule. If they are inadequate, as apparently you agree they are, since you are now, months later, attempting to comply with the requirement in regard to interrogatories, it's your signature, not your paralegal's. It's your signature on the plea. It's your P number that is at risk. No more. All right, let me give you a date. We'll have you back and I'll enter the order. Does June 17th work for both of you?
It does. Your Honor, if I may, the interrogatory responses, he says he's sending them, they're not signed. Could we get a date, maybe if by June 17th, because that's what I had written down, to depose the adjuster in this case?
Let's see how far we're going to go on this. Perhaps after a review of this file with his adjuster and doing the things required by the stipulated order for discovery, we might be in a position to talk about resolution of the file. So if we have not resolved the file on June 17th, Mr. Anderson, I expect you to come to that pretrial hearing if you join us this time.
I will be there on the 17th, Your Honor.
With dates for the deposition of your adjuster. Is there anything else we can accomplish today?
The time on the
It'll be 10
7th.
o'clock like today.
Okay.
Mr. Anderson, did you understand the court's order?
Yes, Your Honor. I am going to make one request and I will understand if the court denies it. The checks are not generated within my office. I have to request the check and it has to be mailed to me. Could I ask for could I have an additional 4 days to get them the attorney's fees check?
You can have 17 days. And
Thank you, Your Honor.
let me make it very clear. setting aside the default is contingent upon timely payment of that $750. Do we have anything else that I was unclear about?
I'm clear, Your Honor.
June 17th, 10 o'clock. Thank you both for coming in. You're off the record. You'll get two.
Judge, you'll write the order out, or do you want me to submit some?
I'll write it out. You're gonna get two separate orders. You're gonna
Thank
get an
you.
order calendaring the pretrial. Then you get an order denying the motion for default judgment for setting aside the default. That setting aside the default will be contingent upon payment of $750 in attorney fees within 17 days of today.
Thank you.
All right,
Thank you.
have a good day.
You too.
Well,
Goodbye, Your Honor.
All right, is anyone here? Is there anyone here on Protector Window versus Cecil Connor?
Michael Norman on behalf of Protector.
Deborah Connor, are you here on that matter?
Yes, one other thing, Your Honor, I just want.
Your Honor, no answer has been filed to my knowledge.
Well, I have an answer here,
Oh, we,
signed by the defendant, Cecil Connor.
okay, we have not been served with that answer.
Let me see if I can get her in here, because I'm not getting her. All right, now, who is this person here? Who is D? I'm not getting this person responding. This person is going back to the waiting room. Mr. Falzon,
Yes, sir.
if I can get this person here on this other case, then we'll get to you just a second. Thank you for your patience. You got your other pretrial done?
I'm sorry, we talked?
Get your other pretrial done?
Yes, sir.
I'll get back to you as soon as I can.
Thank you, sir.
Independent on ourselves, since we don't object to it, we leave it to Mr. Jordan and his client to prove whatever needs to be to the court. All right, everybody good?
All right, is Deborah Connor there? I see somebody on my screen named Deborah Connor, C-O-N-N-Y-E-R. The name signed on the defendant is Cecil Connor, C-O-N-N-Y-E-R. But I am not getting a response to this Deborah Connor person. I have one other place I'm going to try. Let's see if this is this person here. Someone called D. I don't know who that is either. All right, if your name is on my screen is D, unmute yourself and identify yourself, please.
Okay.
I'm not getting a response from that D person either.
I'm not far from you guys. I got a case.
All right, I'm going to call the next case.
I'm going to pick up the other case with Mr. Washington.
This is case number 2115041, Protector Window and Door versus Cecil Connor. This is the date and time set for our pretrial in this matter by a notice dated April 9, 2021. The record should reflect that I have on the video screen the name Deborah Connor, C-O-N-N-Y-E-R. The name of the defendant is Cecil Connor, C-O-N-N-Y-E-R. I have called the Deborah Connor individual on more than one occasion, at least 3. I have taken and requested that the video be turned on and gotten no response to that. We are going to proceed. This matter is set for pretrial at 10 o'clock. It's now 10:37. Let me have your appearance, sir.
Michael Norman, P75844 on behalf of Protector Window and Door.
All right, Mr. Norman, you indicated you do not have an answer here.
That is correct. We did not receive the answer if it was filed, Your Honor.
Okay, I have an answer here signed by a Cecil Connor, who is the named defendant here. As I indicated, the the person who has appeared on the screen is Deborah Connor, C-O-N-N-Y-E-R. But that person has failed to respond either to my request to turn on the video or to my audio request to respond. So this person has failed to appear. We're unable to do anything. What I'm going to do, the defendant has failed to appear. If Deborah Connor appears and wishes to file a motion to set aside the default in this matter, they may. But I'm not going to wait anymore for somebody who apparently dialed in and then has apparently gone somewhere else. So, Mr. Norman, you are asking a complaint for breach of contract for a specified dollar amount?
That is correct, Your Honor. We are requesting $1,300 from the defendant for work completed at their home.
Sir, the defendant has failed to appear. The named defendant is Cecil Condon. The person who is on my screen is a Deborah Condon. As I indicated several times, that person has failed to respond to either my request to audio or to turn on their visual. They failed to file an answer. We will enter default in this matter. Sir, I'm looking forward to your default judgment.
Thank you, Your Honor.
Thank you, sir. We are off the record.
Have a good day.
You too, sir. Mr. Falvin,
Yes, sir.
this is case number 20164-780. The case is entitled Dana Weathington versus Westfield Insurance. By a notice dated April 22nd, this matter is set for hearing today, May 13th at 10 o'clock on the plaintiff's motion to reinstate the case. It is currently 10:40. Sir, could I have your appearance?
Joseph Falls on behalf of the plaintiff.
Bar number.
P80521.
The record should reflect that it is now 10:40. I do not have an appearance from anyone on behalf of Ron Sangster PLC. It's your motion, sir.
Your Honor, first of all, I'd like to apologize to the court. The whole reason for this motion is because I made a mistake on calendaring, in which I did not appear for a pretrial conference. It was totally my fault and not the fault of the client nor anyone else. At this time, the client has been nothing but cooperative during the course of litigation. He has appeared for his deposition and has responded to all discovery requests made by defense counsel. Unfortunately, as I stated earlier, I did not appear for a pretrial conference. And as a result of that, this honorable court dismissed plaintiff's case without prejudice. Upon learning this, I drafted the current motion, and I'm asking the court to reinstate the case. And please accept my apologies, as this is not how I conduct business usually. And I do not enjoy wasting anyone's time, especially this court's.
Have you received any pleadings in opposition to your motion?
I did not, Your Honor.
All right. Well, what I have here is a mistake by counsel. I have a motion to set aside the dismissal that became issued because of that, and I have no response. Under the circumstances you described here, the court's had a chance to read your pleading. I'm convinced that the interest of justice would best be served by reinstating the case so the case can go forward and be decided on its merits. No opposed motion to reinstate the case, sir, is therefore granted. The matter will be set for pretrial on June 17th. June 17th. Does that work for you today, sir?
I will make it work no matter what, Your Honor. Thank you.
10 o'clock, sir.
I will also inform brother counsel.
Thank you, and I'll send out notice today.
Thank you, sir.
We're off the record.
Dave Kanan says hello, by the way.
Tell him I said hello.
I will.
Tell the old guy I said hello.
Yes, sir.
Have a good
Thank you.
don't know who these people are. Morning, gentlemen.
Good morning.
We're on the record calling file number 20153-712, Bass Eagle Transportation versus City of Detroit, your respective appearances.
Good morning. Good morning, Your Honor. Alexander Brown on behalf of the plaintiff, Baz Eagle Transportation, P79951.
Good morning, Your Honor. Michael Lawton on behalf of the City of Detroit, P81884.
All right. When we were last together on April 15th, the court was looking for an order to be submitted by counsel for the defendant granting partial summary disposition. I didn't see that order.
It was sent, Your Honor. Let me.
Judge, I can say it looks like Mr. Otten submitted the order on May 3rd because I received a correspondence with my office CC'd of the proposed order that was being submitted, and that was dated on May 3rd.
Okay, because it has not made my file.
Yeah, so Your Honor, we're really short-staffed on secretaries at the law department right now, and it looks like I submitted it to my secretary. It does look like she sent it. I just pulled it up May 3rd, like Mr. Brown stated. So it would have been filed with the court on that day, and then sent to Mr. Brown as well.
All right. I appreciate everybody's staffing concerns, but the court operates on the basis of written orders. And it's kind of hard to enter an order that hasn't been sent.
Can I have it faxed over today?
Yeah, you can do that.
Okay.
If we can locate it. Where are we then, gentlemen, in regard to balance of the claims in this file?
We spoke this week, Your Honor. Well, our clients are still a little bit apart. If we could actually get a breakout room and chat for a minute, that might be helpful.
All right, can you hold on and see if I can master the technology sufficiently enough to do that?
Absolutely.
Don't bet on it. Breakout rooms. Create. Hello sign. Open all rooms. Alexander Brown. Room 1. Michael Otten. Okay, I think I've sent you guys there.
Thanks, Judge.
Five, three. We are on the record. Calling file number 20156-539, Security Credit Services versus Danita McQueen. Date and time for an adjourned motion for summary disposition. Your appearance.
Good morning, Your Honor. Brad Johnson, P75416, on behalf of the plaintiff.
Danita McQueen.
Okay, good morning.
Good morning.
Mr. Johnson, your motion.
Your Honor, I know the court's read this motion and the response, but just briefly, Ms. McQueen entered into a lease agreement at Robinson Furniture. The merchandise, her main issue is that the signature on the lease agreement is not hers. I will grant her that because it's a DocuSign, which is not, pen to paper or even her drawing it out with a mouse. It's just a form signature that she signed. Her only real argument is that it's not her signature, but that she doesn't say anything about the lease or anything like that.
But I did though.
All right.
I did that in my answer. And even if it's a DocuSign, if you're picking up a signature, it will still be my signature. That is not my signature. A DocuSign won't change how I sign my name.
I mean, I've signed a mortgage agreement with DocuSign, and it just gives you like form signatures.
But your signature will still be the same. It's not going to change your signature. It's not going to change how you sign your name. I don't care. It's going to pick it up. A DocuSign is just a copy, and it's going to pick up your signature. That is not my signature, sir.
I agree with you, but did you lease this furniture from Robinson Furniture?
No, I did not, and I told you that. I told you that in my answer as well.
Okay.
All right, well, here's the problem that we have here. This is a motion under MCR 2.116C10, and the court in this motion claimed that there's no genuine issue of material fact is required to be liberal in finding the existence of a genuine issue of material fact. Now, what we have here is the answer filed on behalf to the motion on behalf of the defendant. She denies that she entered into this agreement. Further, she gave us copies of expired driver's licenses, which have signatures which are apparently quite different, even to the court's untrained eye, to the signature that appears on the document provided on behalf of the plaintiff in this matter. Because I am required to be liberal in finding a genuine issue of material fact, the plaintiff's motion for summary disposition must be denied. I'll send you out an order denying that, and we'll set the file for pretrial. Your next date will be June 17th at 11 o'clock. June 17th at 11 o'clock. Does that day work for everybody?
Let me check, Your Honor, briefly. That works for me.
Does that work for you, ma'am?
Yes. So what are we doing now? The date is fine with me. I just need to understand what we're doing.
It'll be a pretrial like today. The motion is being denied. I'll
Okay.
order in that regard. Thank you both for coming in.
Okay.
You're
Thank
off.
Thank you.
Thank you, Your Honor.
Thank you.
Okay, we're back on the record, recalling file number 2015371, Boz Eagle Transport versus City of Detroit. Gentlemen, your appearance.
Good morning, Your Honor. Alexander Brown on behalf of the plaintiff, Baz Eagle Transportation, P79951.
Morning, Your Honor. Michael Lawton on behalf of the City of Detroit, P81884.
So Were you guys able to settle this file?
Your Honor, we think that we're getting close. Mike and I had a chance to discuss a number that we think both of our clients will be happy with in getting this matter resolved. So we would just ask the court for maybe 14 days, a 14-day adjournment, and we're hopeful that the matter can resolve in between time.
Mr. Allen?
Correct, Your Honor.
All right, so let me get my calendar out here. Let's see if we can get you guys back here today. So that will be around the 27th or so of May. That'll give us 2 Thursdays. Does May 27 work for both you gentlemen?
Will work, Judge.
It
What
does.
about you, Al? All right, May 27th then
All right.
at 11 o'clock. Let's get this one done, gentlemen.
Will do. Thanks, Your Honor.
Okay, thank you for coming in. We're off the record. We are on the record calling 20159-628 Gravity Imaging versus Wayne County. This matter is enough set for pretrial at 11 o'clock. Could I have your appearance?
Morning, Your Honor. Daniel Groves on behalf of the plaintiff, Gravity Imaging, P number 74026.
Okay, I'm connecting to audio with some person described as D. It's D here. That doesn't seem to be working. Let's see. Put D in the waiting room and then bring D back, see if that helps us. D? Is a person named D here on the Zoom call? I'm not getting an answer. Do you see this, Mr. Groves, this person D? Do you see the name on your
I
screen?
see, yes, Your Honor, I see D. I see it. Yes. It's no picture. It's just a blank
No
screen
picture,
with the name.
no audio either, apparently. Well, at this point, we're scheduled at 11 o'clock. Have you guys by any chance settled the case? Is that why you're calling me?
No, sir. It has not settled and
Then we'll have to wait, give them till 11:30,
very well, Your Honor.
about another 15 minutes and see whether or not the other side appears. If not, I'll get back to you at 11:31.
Thank you, sir.
I'll put you back in the waiting room along with, and this D person seems to have left. Maybe they were in the wrong place. But
Okay.
put you back in the waiting room.
Thank you.
Thank you, sir. All right, let's put these two away. Germans. We are on the record calling file number 20159-628. This file is entitled Gravity Imaging versus Wayne County by notice dated April 15, 2021. This matter set for pretrial today, May 13th at 11 o'clock. It's currently 11:31. Could I have your appearance, sir?
Good morning, Your Honor. Daniel Groves on behalf of the plaintiff Gravity Imaging, respectfully P number 74026.
I don't have a defendant, Mr. Groves.
It would, if it would be amenable to the court, plaintiff moves for default, but in the alternative, if not, then plaintiff would defer to the court on the next action if it's going to reschedule the hearing.
The plaintiff has failed to, the plaintiff has appeared, the defendant has failed to appear. No good cause that fair having been shown. The default of the defendant is hereby entered. You may file your motion, sir, for default judgment.
I'm sorry, Your Honor, file the motion or file the order?
No, I'll enter the order for the default. But this is not a certain case. So you have to file a motion for a default judgment.
Yes, sir. Very well. Thank you, Your Honor.
Look forward to receiving you, sir. Have a good day.
Thank you. Have a good day, Your Honor.
Come again, sir.